In this week's in-depth conversation, we discuss exoneration for people convicted of crimes in Oklahoma. How often does it happen? And does it happen too often or not enough? We're pleased this week to welcome the newest member of our Oklahoma News Report family, moderator Cassidy Mudd, with this week's panel of guests. Cassidy, it's all yours.
Thanks, Rich. Happy to be a part of the team. Joining us for this discussion is Representative McDougal for Broken Arrow and Andrea Miller, the legal director for the Oklahoma Innocence Project. Thanks for joining us, guys.
Thank you so much for having us.
Thank you. How difficult is it to get a new trial in Oklahoma, let alone to be exonerated?
It's very difficult. Once a jury has made a determination of guilt, you have to come up with some really substantial new evidence of innocence, meaning it has to be something that wasn't previously presented at trial. And then you have to maneuver through a court system where judges are accustomed to correcting legal error, but they are not accustomed to correcting factual error. They feel like there's been a jury verdict and the jury verdict needs to stand. So it's a very high burden that you face in trying to get a new trial, and then trying to get exonerated just adds to what we have to show in terms of new evidence of innocence.
What does that process look like?
Well, for most of our cases at the Oklahoma Innocence Project, what we do is we get a request from an inmate. We currently have about a 500 case backlog, and students in the clinic work with me. If I decide that it looks like maybe there's a path to innocence, we begin an investigation. We collect records, we hire an investigator, we re-interview witnesses. Often we are interviewing witnesses who have never been interviewed before, trying to get new information. On the cases of actual innocence, what I'm finding is usually those pieces fall into place. Usually once somebody actually reaches out and starts interviewing people and starts looking at kind of going back and reinvestigating the case from ground zero, typically the evidence just kind of leads to more evidence until we can make what we believe is a case of innocence. And at that point, then we go into state post-conviction, which is the mechanism to try to get back into court. The difficulty with that is if you've waited too long, the court will throw out the case. And so you're kind of against the clock even if you're not against the clock. We now have the added difficulty of a one-year statute of limitations under the Post-Conviction Act, which is going to foreclose a lot of innocent people from actually being able to get back into court. While we know what causes wrongful convictions, the court system hasn't quite caught up yet with what we know happens, and allowing appellate courts and federal habeas courts the authority to try to fact correct essentially in these cases.
What are some things that can cause a wrongful conviction?
Well, we know that eyewitness identification evidence is a major contributor. Often witnesses, even trying their best to be helpful to law enforcement, just can pick out the wrong person or not very good at identifying people. Faulty forensic evidence, so we have a lot of cases where we are backwards looking at convictions based on faulty hair comparison testimony or maybe early versions of DNA that weren't very reliable. A lot of cases are impacted by prosecutorial misconduct, and a lot of cases are also impacted by ineffective assistance of trial counsel, where trial counsel did not conduct the kind of investigation that we are now trying to go back and conduct after the fact.
Well, Representative McDougal, you got a kind of a close-up look of that process because of your involvement with the Richard Glossip case. Can you speak a little bit about your experience and what you learned?
Absolutely. I think some of the biggest reasons in the Richard Glossip case is ineffective counsel. They did not do any type of investigation. They relied on the investigation that was done by law enforcement, which was not adequate in and of itself. The state actually, in his case, destroyed evidence. A box of 10 items of evidence in between his two trials. And why do we as a state allow that to happen? No one filed any charges against the people who misplaced or destroyed the evidence. In fact, they did it on purpose by creating it under a different file number so that no one would be able to find it. In his case, one of the prosecutors had one of the witnesses change testimony in order to reflect exactly what their narrative was. So in his case, even though it's obvious and we have proof of all this, the courts look at it and say, no, there's nothing to see here, and continue to push it down the road, because if this case is ineffective, that means possibly other cases, and they don't want to open that door. So in Oklahoma, it seems that once you go through this process, it's very difficult to get out because they don't want to admit that there's ever been wrongdoing along the way.
And I want you to speak a little bit more to that, why that is happening.
Yeah, I think that our legal system feels like if they admit guilt at any point in time, or if they stand up and say, hey, you know what, we had somebody back then that was ineffective, or somebody that was willing to lie to get a conviction, or somebody that was willing to twist the truth, if we stand up and say that, then that makes our legal system faulted. My belief is that if you stand up and admit when you did go wrong and correct that wrong, then there's more trust and faith in the legal system. I have very little faith in the legal system at this point because I've seen so many times that our courts simply say there's nothing to see here when there's enough evidence all along the way to prove in the Richard Glossip case. We know he did not commit the murder, for instance. Could he have been guilty of coercion? Yes, he could have been guilty of a few things like that, but murder he's not guilty of. And for some reason, in this particular case, we're going to give somebody life in prison who actually committed the murder for testifying against someone else.
I mean, just going off of that, as we're working to seek justice for those wrongly convicted, and this is for either of you, how do we ensure that the rights of the innocent victims and their families are not being forgotten?
It's complicated, but you would hope that when there is a legitimate challenge to a conviction based on actual innocence, the people who are most communicating with the victim's family is the state, the prosecutors. And you would hope that they would have enough courage to admit that maybe they got it wrong, but that's typically not what we see. And so it is very difficult for victims' families. We have a policy where we don't reach out. If they would reach out to us, we would definitely discuss the case with them to the extent that we can. But it really is on the state, and as Representative McDougal just mentioned, since nobody's ever willing to admit they made a mistake, then often the victim's family members are left in a position where they continue to believe in somebody's guilt, even if the evidence shows that it is unlikely that person committed the crime.
And that's a fact in the Richard Glossip case. Outside of Richard Glossip, there was 2 other death penalty cases where they were on death row and they were exonerated because of DNA evidence. Now, the victims of the murdered person, they were angry at those 2 individuals. They wanted to see them put to death. And then all of a sudden, they find out for a fact that they're not guilty. That changes, right? They are so thankful now that they didn't see those people put to death. In the Richard Glossip case, it's almost like the state doubled down. And it's unfair to the family, the victim's family, to continue this lie when you know that there's evidence to back up that they should not be on death row in the first place. And when they went to the hearing at Pardon and Parole Board for Richard Glossip, the DA's council had a number of DAs stand up to represent and stand with the family and say, he's guilty, he's guilty, he's guilty, these guys are lying, there's nothing to see here. That causes more trauma to that family than anything else. And so I think it's a fine line that you've got to walk. You want the family to have representation, but you want them to fully understand and not be lied to that there's no evidence when there is.
Tell us a little bit about the bill you introduced last session that would establish the Death Penalty Conviction Integrity Unit, and how do you see that going forward to be voted on in the Senate and in the House?
Yeah, I don't see it going anywhere right now, and the reason is the conviction unit would basically say that if you have enough evidence to go to an outside counsel and let them do a third-party investigation, right? Well, we did that with Richard Glossip. We actually, I didn't hire, but they volunteered their time, over $1 million in time and effort from the Reed Smith law firm that they put into this case. And they did the investigative work that no one had done before, other than the defense team. But I didn't want to take the defense team word for it. And when we initiated this, I told them, I said, I want you to tell me, is he guilty? If he's guilty, I'll stand with that. If he's not guilty and evidence shows that, I want to know. But I've got the defense telling me he's not guilty. I've got the prosecution telling me he is guilty. So who do you believe? And so the third party went out and they came back with a 350-page report. And when it went to the courts, in fact, it went through 2 AGs. The AGs basically ignored it. Finally, the third AG, Attorney General Gettner Drummond, I told him, I said, please personally look into this. Don't trust your staff on this one. Look into it personally. The very first time we met with him on this case, he walked in the room and said, I know he's guilty, but I'm here to listen. And I said, AG, that's all I've asked. is for you to listen. Then when he went, he hired his own third-party investigator to do a full investigation and came back with the same conclusion that we did, that you couldn't trust those first 2 trials. So I'm thinking, hey, this is great. Now we've got the AG of Oklahoma that's basically saying we've got to vacate charges and retry. But when it goes to the Court of Criminal Appeals, they threw it out and said, no, you can't trust the AG's opinion on this. This is the top law enforcement officer of the state of Oklahoma that's made this decision, and the court said, no, we're going to ignore that, put him to death. Then it went to Pardon and Parole Board, and that's when the DA's counsel stood against it and tried to get him put to death. Thank God they filed it, and it's now before the Supreme Court on his particular case.
What's really interesting about Mr. Glossop's case, and is not different than a lot of our cases, is the new evidence was actually evidence that should have been turned over or shouldn't have happened in the first place, because one of it involves potentially an assistant district attorney providing a report to the testifying witness before he testified to make sure that his testimony was consistent. The benefit Mr. Glossop has gotten is they have gotten access to all that information for this third-party review. In our cases, most of the time we are not working cooperatively with the state of Oklahoma, and we are locked out from that sort of evidence that could possibly at least create a substantial constitutional violation, even if it doesn't necessarily prove innocence. And so what Mr. Glossop has gone through is not atypical of a lot of the cases we see, but since he's had a little bit more of a spotlight on his case. But that is a recurring theme in a lot of our cases. It's a problem because we have an appellate court who seems unwilling to recognize that the prosecution has a duty to turn over specifically evidence that could be helpful to the defense. It's a continuing duty. It goes through all the way through post-conviction, and yet we are not getting that sort of disclosure on cases that we are litigating. So it is a substantial problem in wrongful conviction cases.
And part of the reason that Richard Glossop has access to that is simply because when it was brought to our attention as a legislator, we stood and we fought to get that information. Well, now there's eyes of the legislator on it. Well, that's part of why the DA's counsel was upset, is why is the legislator involved in our court cases? They should stay in their own lane. And I would. If we had a mechanism in our courts for our courts to be able to correct themselves, then the legislator wouldn't have to get involved at all. But when a citizen of our state, our constituents come to us and say we've got a real issue here and nobody's listening, then we have to take a stand.
I was kind of wondering, Andrea, what resources are available for people getting out of prison, especially for those like Mr. Simmons, who spent almost 5 decades behind bars for a crime that he didn't commit?
And Mr. Simmons is a great victory for he and his attorneys. And we're very excited that Oklahoma County decided to do the right thing and release him. It's a very hard path once you get out. And, you know, it's hard if somebody spends a few years in prison wrongfully convicted. The average in Oklahoma length of time for an exoneration is 10 years from the time that the case is worked on. Now, we have cases that fall in between that. So we just got a murder case vacated for a client who was convicted in 2014. I just got a favorable habeas ruling for a client whose habeas petition has been pending since 2009. Either way, those people need help. They need financial help. They need services, mental health counseling. Prison is bad for one's mental health under the best of circumstances, and to be put there when you did not do anything to be put there is a real problem. And so they need a lot of help. There's also the potential that at some point Oklahoma will revise its compensation statute and move to a model similar to what the state of Kansas has adopted, where not only are you providing some monetary compensation, but you're also providing health benefits, mental health benefits, housing benefits, education benefits. I mean, it would be a monumental shift for the people who have experienced and been the victim of a wrongful conviction to have those sorts of resources readily available, and hopefully quicker than it takes. Right now, it takes a long time for somebody to even seek compensation under Oklahoma statute, so hopefully maybe there's a mechanism to speed that process up a little bit. But they need a lot, and they need a lot of help, and they need a lot of support.
Absolutely. Well, guys, that's about all the time that we have. Representative McDougal, Andrea, I appreciate you guys both for coming, and I appreciate you guys both working so intensely on this.
Thank you.
Thank you so much.
Thank you.
Absolutely.
you.